today on UPSC Polity View. As social media grows and continues to grow, and people all over the world start sharing their points of views, what are the implications of the various laws and acts that we have in the Constitution today, and what needs to change? Hello and welcome to UPSC Polity View at UPSC Practice. Let's learn about Section 66A of the Information Technology Act. From its establishment as an amendment to the original Act in 2008, Section 66A attracted controversy over its unconstitutional nature. The Section 66A is based on the offence of publishing offensive, false, or threatening information. The description says, any person who sends by any means of a computer resource any information that is grossly offensive or has a menacing character, or any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, shall be punishable with imprisonment for a term which may extend to 3 years and with fine. The penalty, imprisonment up to 3 years with fine. In December 2012, P. Rajiv, a Rajya Sabha member from Kerala, tried to pass a resolution seeking to amend the Section 66A. He was supported by Dr. D. Bandopadhyay, Gyan Prakash Pilania, Basavaraj Patil Sadam, Narendra Kumar Kashyap, Ramachandra Khuntia, and Vaishnav Charan Parida. P. Rajiv pointed that cartoons and editorials allowed in traditional media were being censored in the new media. He also said that law was barely debated before being passed in December 2008. Rajiv Chandrasekhar suggested the 66A should only apply to person-to-person communication, pointing to a similar section under the Indian Post Office Act 1898. Shantaram Naik opposed any changes, saying that the misuse of law was sufficient to warrant changes. The then Minister for Communications and Information Technology, Mr. Kapil Sibal, defended the existing law, saying that similar laws existed in US and UK. He also said that a similar provision existed under Indian Post Office Act 1898. However, P. Rajiv said that the UK dealt only with communication from person to person. What petitions challenging the constitutionality exist today? In November 2012, IPS officer Amitabh Thakur and his wife, social activist Nutan Thakur, filed a petition in the Lucknow bench of the Allahabad High Court claiming that the Section 66A violated the freedom of speech guaranteed in the Article 19(1)A of the Constitution of India. They said that the section was vague and frequently misused. Also in November 2012, a Delhi-based law student, Shreya Singhal, filed a public interest litigation or PIL in the Supreme Court of India. She argued that the Section 66A was vaguely phrased. As a result, it violated Article 14, 19(1)A and Article 21 of the Constitution. The PIL was accepted on 29th November 2012. A similar petition was also filed by the founder of mouthshut.com, Faisal Faruqi, and NGO Common Cause, represented by Prashant Bhushan. In August 2014, the Supreme Court asked the central government to respond to petitions filed by mouthshut.com and later petition filed by the Internet and Mobile Association of India or IAMAI, which claimed that the IT Act gave the government power to arbitrarily remove user-generated content. The revocation by the Supreme Court happened on 24th March 2015. The Supreme Court of India gave the verdict that Section 66A is unconstitutional in entirety. The court said that Section 66A of IT Act 2000 is arbitrarily, excessively, and disproportionately invading the right of free speech provided under Article 19(1) of the Constitution of India. But the court turned down a plea to strike down sections 69A and 79 of the Act, which deal with the procedure and safeguards for blocking certain websites. Let's hear what the Minister of Communication and Information Technology, Ravi Shankar Prasad, had to say regarding this.
We respect freedom of speech and expression, We respect communication of ideas on social media. And we are not in favor of curtailing communication of honest dissent, opinion, disapproval or criticism on social media. And 666A of IT cannot be interpreted in any manner so as to curtail these ideas enshrined under Article 19(1) of the Constitution. And it is very important to be noted that in our new affidavit filed, apart from reiterating these new positions, on behalf of the Government of India, we had clearly conveyed that if Article 666A, Section 666A of the IT Act cannot be interpreted in consonance with Article 19(1) read with 19(2), then we don't support that interpretation at all. Our view was very clearly conveyed in writing. It is a part of record. When the hearing commenced, on our instruction, the Additional Solicitor General Sri Tushar Mehta had also conveyed a request to the bench that the government is willing to come with additional, more stringent guidelines so as to prevent abuse of Section 666A of the Act. But the Honorable Court in its wisdom said that now, since we are hearing the validity of this provision, we will continue. This is how the judgment has come. Again, as I said earlier, I will convey a structured response after going to the judgment, which I must. I am awaiting the receipt of the judgment. But the Government of India's stand, quite different from the previous government, has been very clear and consistent.
Thank you very much for listening to this discussion on the Section 66A of the Indian IT Act. For more such articles and discussions, install the UPSC Practice app from the App Store.